Welcome to literary and jury charge practice. Let's get started. Ready? After the closing arguments, the judge instructs the jury on the burden of proof, the law that applies to the case, and how the jury must apply the law to the facts of the case. Remember, it is the jury who decides the facts. It is the judge who decides the law. Jury instructions can be very lengthy, convoluted, and difficult for the average juror to understand. The danger here is that the jurors may disregard the instructions and decide the case on what they feel the law ought to be, not what it is. The jury members usually select a leader before they begin deliberations. They deliberate in the jury room. They weigh the evidence, decide which witnesses were telling the truth, and reach a verdict in favor of one party. They may ask to see some of the exhibits again, have trial testimony reread, or have the judge give a further explanation of jury instructions. Jurors in civil trials are almost never isolated or sequestered from the public and the media during the course of the trial and deliberations. When a verdict is reached, the jury files back into the courtroom. The judge asks the foreperson whether the jury has come to a verdict. The foreperson replies affirmatively. If you help someone plan a robbery, you help them before the crime is committed. You are an accessory before the fact. If you hide a person who has committed a crime, you are an accessory after the fact. If you actually participate while the crime is taking place, you are an accomplice. Larceny is theft. Theft is the unlawful taking and carrying away of another person's personal property with the intent to permanently deprive the owner. Larceny is categorized into two types, grand or small. Grand larceny is stealing on a large scale. Petty larceny is stealing on a small scale. Grand larceny is a felony. Petty larceny is a misdemeanor. The difference between grand larceny and petty larceny is determined by the value of the property taken. The crime of embezzlement is similar to theft in that it is stealing, but it is stealing something that someone else has entrusted to you. Embezzlement starts with the lawful possession of the property. All right, just a lot of legal terms there. Let's see, we had embezzlement, sequestered, accessory. We had accessory before the fact, accessory after the fact, larceny, so let's move along to some jury charge material. Ready? Ladies and gentlemen of the jury, you have heard all the evidence in the case, and now you have heard the arguments of the attorneys, and now it has become my duty to instruct you as to the law which applies in this case. The law requires that I read these instructions to you, so you should pay very close attention to what I say to you now. If you wish to, you may take notes on these instructions. In arriving at your decision in this case, you must base your decision on the facts and on the law. In a sense, you have two duties to perform. The first duty is to determine the facts from the evidence that has been received in this trial, and not from any other source. A fact is something that is proved either directly or circumstantially by the evidence. Your second duty is that you must apply the law as I state it to you to those facts as you determine the facts to exist, and in this way arrive at your decision or verdict in the case. Further, you must accept and follow the law as I state it to you at this time, whether or not you agree with that law. If anything concerning the law said by the attorneys during the course of their arguments has seemed to differ or conflict with my instructions, you will disregard what the attorneys have said, and you will follow my instructions. Whenever children, particularly very young children, are involved in a case, strong emotions may be aroused. Everyone was a child at one point in time. Many remember young sisters or brothers growing up. Many may be parents of children. Remember what I indicated to you at the beginning of the case during the jury selection process. That is, in arriving at your decisions in this case, you must not and should not be influenced by your subjective emotional response either to the evidence or the individuals involved in the case. You must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is any evidence of his guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. All right, now let's do some literary material, practice some literary material from the Journal of Court Reporting. This is an article that's called 7 Ways to Differentiate Yourself as a Job Candidate. Ready? According to industry projections, in less than 5 years, the demand for court reporting will exceed supply, resulting in more than 5,000 open positions. However, you cannot assume that simply having a court reporting degree will get you hired. Naturally, the most important piece to getting hired is to hone your craft, and you can only do so through practice, but this alone is not enough, as everyone else looking for court reporting and captioning positions will have the same skill sets. Whether you are a student or a seasoned professional looking for a new opportunity, these 7 principles will help you secure that next job. Networking. Everyone you meet is part of your network and could end up being instrumental in helping you build a successful career, and you should treat them accordingly. Always be courteous and professional in your interactions. This includes instructors and classmates in school, people you meet at your state association and NCRA events, and people you meet at your internships. Kathy Carpenter, a freelance reporter from Seminole, Florida, and the 2016 recipient of NCRF's new professional reporter grant, agrees that networking is a must. I can't stress enough how important it is to network with as many reporters as you can, Carpenter says. The knowledge and support I get from others in our field is invaluable. There are a lot of firms out there. Speak with multiple reporters who work for different firms to get information on policies and procedures, and then find the best fit for you. Get involved. Getting involved with an organization such as NCRA or your state association provides an opportunity to network and show other reporters and future employers how passionate you are about the profession. I met one of the owners of the firm I work with through our state association while I was a student, and after my initial phone call, another reporter that was in the office at the time remembered me from past conventions, says Carpenter. Court reporters love to help students, and they remember the ones that attend meetings and conventions and ask questions. Make the most of your membership by attending events and joining a committee. As a student, you can earn a free membership to NCRA through NCRF's Oral Histories program by transcribing 2 interviews, and it doubles as great practice to hone your craft. Okay, let's get back to, some jury charge practice. Ready? Both the people and the defendant, Mr. Myers, have a right to expect that you will consider and weigh all the evidence that you have heard and seen, that you will apply the law as I will state it to you now, and that you will reach a just verdict regardless of the consequences. To put it another way, you may use your common sense at arriving at a decision in the case. You must judge the evidence and determine the facts using your head and not your heart. In your deliberations, you should not consider or discuss the penalty in any way. Those are subjects which must not in any way affect your verdict or decision in this matter. The statements of the attorneys at all times during the course of the trial are not evidence. Attorneys are not witnesses. If anything said by the attorneys about the evidence during their closing arguments has seemed to depart from your individual or your corporate recollection of the evidence, you must rely on what you heard and what you saw. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection or the reason for the question. Do not assume to be true any insinuations that was suggested by a question asked a witness. A question coming from the mouth of an attorney is not evidence and may be considered by you only insofar as it enables you to understand the answer which comes from the mouth of a witness under oath. Do not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken by the court. You should treat those instances as though they never occurred. Under the law, evidence consists of the testimony of witnesses, writings, material objects, or anything which is presented to the senses and offered to prove the existence or non-existence of a particular fact. Under the law, evidence is divided into two general categories: direct evidence and circumstantial evidence. Direct evidence is evidence which directly proves a fact without the necessity of an inference. It is evidence which, if you believe it, establishes that particular fact. Circumstantial evidence, on the other hand, is evidence, if found to be true, proves a fact from which an inference may be drawn, or the existence of another fact. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts which have been established by the evidence. Let's get back to our article from the Journal of Court Reporting regarding differentiating yourself as a job candidate. Ready? Find a mentor. I was very fortunate to grow up with a family-owned court reporting business, says Angela Baker, RPR, president of Depot International. When I was 12, I began frequenting the Depot International office after school and in the summer times. I thought it was super fun to work in the production department with all of the fancy copy machines and stamps and assortment of pens and Post-its galore. My mom, court reporter extraordinaire Patricia Carl, still brings up the time my bestie tagged along with me to the office and we made up our own business cards for Angela Carl and Associates. That's really where it all started. Even without a familial connection, you can find a mentor. Find a court reporter or captioner whom you admire and ask them if they'd be willing to meet for coffee or schedule a phone call to discuss the profession. The term mentor often sounds more official than it needs to be It can be a casual relationship between an established professional and an aspiring one, built through an initial conversation soliciting advice. You might even already have a mentor without realizing it. Once you have a meeting set up, prepare a few initial questions. For example, how did you get into court reporting? What advice would you give a student like me who aspires to own my own firm? Then let the conversation flow from there. The last question you ask should always be, "May I stay in touch with you?" With their permission, you can continue to reach out periodically to ask a question, share an exciting update, or schedule another coffee or lunch. You should follow up after the initial meeting with a thank you, since the person is likely a busy professional who took time away from work to help you. This can be an email, but a handwritten thank you note will set you apart. After a few interactions, you'll have built a relationship, and when you're job hunting, you can ask this person if they have any advice on where to look. All right, that will conclude our literary and jury charge practice.